Hi viewers, greetings of the day to all of you. We welcome you on behalf of NRI Legal Services. We are back with you with another session of Ask Me Anything. We have been holding Ask Me Anything sessions for the benefit of the NRIs. You are welcome to ask questions on today's topic of Ask Me Anything. And the today's topic is the various types of dates and legalities involved therein. We'll discuss in detail what are the dates prevalent in India and also the legalities involved pertaining to those dates. During this session, I will be assisted by my senior legal associate. She is Advocate Akriti.
Hello viewers.
Advocate Akriti will be also answering your questions. You are therefore requested to shoot your questions. It would be our endeavor to clarify all the issues and inquiry which you are raising before us. So first of all, let me explain to you that when you have to transfer the property, there are various types of dates. One is initially we have to handle the transfer date, then sale date. There can be gift date also for transfer of property. Then there can be relinquishment date. There can be family settlement date for settlement of the properties. But if you have to transfer the property through these kinds of dates, the three basic elements which you must know, the legal elements which has to be taken care of. First element is that the transfer can be only between living persons. If a person is not living, there can be no transfer on his behalf. So living persons have to be there. Living persons, as per the Transfer of Property Act, also include a company or association of individuals. So they are also entitled to transfer the property. The second most important element is that the property must be transferable. If the property is not transferable, then the transfer will be invalid. Non-transferable properties are like public funds, public offices. These things cannot be transferred. And then thirdly, the most important thing is that the person's competency, whether the person who is transferring the property, whether he is capable of transferring, means thereby that he should not be insane, he should not be minor, and he should be capable, medically fit to transfer the property. And I'll continue with this discussion. I find that there is some question which is coming up.
Yes.
And Kriti, can you read the question?
Sure, sir. So there is one question from Ms. Jaiswal. I'm a non-resident Indian and I want to buy a residential property in Bangalore. The seller has told me that the sale deed will be valid on the basis of the agreement to sell being executed between us. Is it correct? So first of all, thank you so much for your question. And I would like to clarify, Ms. Jaiswal, that the seller is misguiding you because a sale cannot be complete if it is not duly registered at the office of sub-registrar. So to make any sale valid, it is very important to register the sale deed in the office of concerned sub-registrar so that you can avoid any sort of legal complications in future. So it is very essential to get it registered and you should not rely upon the agreement to sell.
Okay, you can refresh it.
Yes.
Okay. Now, any other question? Not so far?
Not so far, sir.
Okay. Let me tell you that the various types of dates which I was discussing, one of the important date is sale date. When you have to enter into a sale date, there's basic elements of the sale date which have to be taken care of. What are those elements of sale date? The basic element of sale date is that when you are drafting a sale deed, the details of the buyer and the seller should be clearly mentioned in the sale deed. Secondly, the details of the property should be clearly brought out, means the area of the property should be specified, the location of the property should be specified. There should be no ambiguity regarding the details of the property. Thirdly, since it is a sale deed, then the consideration amount involved should be clearly mentioned, and what is the mode of payment. The mode of payment should also be clearly brought out in the sale deed. Fourthly, when the sale deed is being drafted, there should be the possession part of the property, that when the possession is going to be handed over, it should also be clearly mentioned. Then in case there is any encumbrance on the property, that encumbrance should be clearly brought out, that there is any loan on the property or there is something, some mortgage on the property pending, that should also be clearly brought out. If any utility bills or property tax bills are there pending, that should also be clearly brought out. Moreover, the sale date, when finalized, it should be clearly, it should be signed by the buyer as well as the seller, and it should be signed on each page. And furthermore, when the sale deed is being finalized, there should be witnesses also present during the sale deed. If the witnesses are not there and all these formalities which are required for the drafting of the sale deed are not completed, then the sale deed can be termed as invalid. So all these details must be mentioned in the sale deed. And how the sale deed is registered, I will discuss with you. Before that, we'll take question. I think some question has come up.
Yes, sir. So there is a question from Ms. Shivani Sood, that if a person has a relation with a female other than his wife and he gifts his property to that lady, is it a valid gift?
Okay. Let me handle this question, Akirti.
Yes.
Now we are talking about that if a person is having a relation with any other female, can he transfer his property to that female? It can be by way of gift. That is what it is being proposed to. It seems that must be the gift is the only part by way the gentleman may be trying to transfer the property to the lady. Earlier, it was held by the High Court that if a person is having a relation with a female and she is being kept as a mistress, so it is considered to be immoral consideration. But now the Honorable Supreme Court has clarified in detail that if a person is exclusive owner of the property and he has the consent and he is willingly giving the property and it is his self-acquired property, then this gentleman can transfer the property, and there is no ground that this sale can be treated as this gift can be treated as invalid gift. So every person is at liberty and it is no one's concern that to whom the property is being transferred. It is the will and the voluntariness of the person who is giving the property by way of gift to whomsoever he wants to give. So in your case, the gift it will be a valid gift. Okay. Any other question?
Yes, sir. There is one more question from Mr. Himanshu. That hello, I am resident of UK and have a flat in Mumbai. I want to sell this flat. Can the flat be sold through attorney holder without me coming to India?
Okay. Himanshu, thanks for your question. Now you want to sell this flat without coming to India. Let me explain to you that it is possible, and there are law firms who are handling such type of work, and you can give power of attorney to one of the trusted persons of that law firm, or if you have your own trusted person, you can hand over the power of attorney to that person, and the property can be sold on the basis of that power of attorney holder. But you must be clear that it is a general power of attorney which is giving the person to whom you are giving the power, he should be a trusted person and he should be given that right to sell the property. Secondly, when you are giving a general power of attorney, you must ensure that this general power of attorney is duly apostilled in the country of your residence, and also when it is to be used in India, then this power of attorney should be duly embossed in India of the jurisdiction concerned, and thereafter it becomes a valid power of attorney. And on the basis of such valid power of attorney, the property can be sold by your POA, power of attorney holder. Any other question?
Sir, I believe, sir, can you please throw some light on, sir, which regarding the sale proceeds and its repatriation?
Okay. So far as repatriation of sale proceed is concerned, like if I link this with the same question, the repatriation of funds can also be done through your account maintained in India. Whatever sale proceeds you get from this sale, those sale proceeds will be treated as a capital gain to you, and after deducting the capital gain tax, then the property after deducting the capital gain tax, the balance of the fund can be repatriated through your account to the country of your origin. Any other question?
I think so we are still waiting for a few more questions.
Okay.
And
I was talking about sale deed and its registration. Let me clarify to you that sale deed is not valid until it is registered. Under the Registration Act 1908, the sale deed has to be mandatorily registered, and when the sale deed has to be registered, we have to ensure that it is duly drafted on a non-judicial stamp paper, and also you have to say that the stamp duty on the value of the property is duly paid. The stamp duty has to be paid by the buyer of the property. Once the stamp duty has been paid, then the sale deed can be sent for registration to the registrar office of the concerned area. And so far as this registration is concerned, let me clarify that the registration can be sought from the office of an appointment can be sought from the office of the registrar, and once the appointment is given, then on the appointed day the buyer as well as the seller, they have to be present before the office of the registrar, and subsequently the registrar verifies the documents, that is the ownership documents, because the seller should have the ownership documents with him, and then after verifying all the documents including the ID proofs of the seller and the buyer, the property the registration can be done. And furthermore at the time of the registration, it should be ensured that the witnesses are present during the registration process, have to sign on each page of the sale deed.
right.
These are the basic procedures to be followed at the office of the registrar at the time of the registration of the sale deed. Any other question?
Yes, sir. There is one question from Mr. Sunil that hi, I want to buy a property in Punjab, limitage of stamp duty, and in addition to the price of the property, he has quoted the stamp duty approximately 6 to 7%. Can you guide on this? May I handle this question,
Please.
sir? So, Mr. Sunil, as per the existing provisions of law, each state government has been charging certain amount of stamp duty based on the circle rate of the property in question. This stamp duty has to be borne by the buyer itself, and it varies from state to state. Since you are talking about Punjab, then in case of Punjab, when the property is bought by a female, then the stamp duty is 6%. When it is bought by a male, then the stamp duty is 7%. And in case the property is being bought in the joint name, then the stamp duty applicable on the circle rate will be 7%. I hope this clarifies your concern.
Yeah, it is clear. Any other question?
Yes, sir. There is one question from Mr. Sameer that, hi, I am a senior citizen. I have gifted my only property to my son. I am fully dependent on my son for my day-to-day living. Presently, he is not looking after me at all. Can I take back my property from him?
Yes, Mr. Sunil, thanks for your question. Let me clarify to you here that you being a parent, you are entitled to maintenance from your son, and if you have gifted your entire property to your son, then under the Senior Citizenship Act, you have the right to get back the property from your son, and this property can be recovered from the son in case he is not maintaining you through the court process of court, and the very clear provisions, and you can easily claim back the property, and then you can dispose of the property and maintain yourself. But it is very touching that the parents are not being looked after by the children. That's why the state governments had brought out the Senior Citizenship Act, into force in various states. So you can claim back your property from your son.
Right. So there is one more question from Mr. Mintu Arora that hi, I have an agricultural land in joint ownership with my siblings. Can I get my share demarcated?
Okay. What is the name of this person?
Mr. Arora.
Okay. Hello, Mr. Arora. So far as your query is concerned, that the property can be demarcated or not. Whenever you are co-owning a property and there are co-sharers in the property, then the property can be demarcated by way of partition deed. Since we are talking about the deeds, partition deed is one of the deed for the partition of the property. A partition deed has to be made by all the members, in your case all the siblings who are co-sharing the property with you. They have to prepare a partition deed. The partition deed should clearly specify the share of each person, duly demarcated, and thereafter that partition deed can be registered, and on the basis of that partition deed the property can be demarcated, and then you can get your share through this partition deed through the revenue authorities. And once your share has been demarcated, it has been then that share can be disposed of as you have become the sole owner of the demarcated share.
Sir, there is one more question. That is it compulsory to register the sale deed at the office of sub-registrar, or the sale deed duly attested by notary public is a valid sale?
Okay. Who is the gentleman?
Sir, this is just
okay. Let me clarify it. The sale deed, as I told you, has to be duly registered in accordance with the Registration Act of 1908. If the sale deed is not registered, it is not a valid sale deed. Let me clarify that if the sale deed has been notarized by notary public has attested the sale deed, bringing out that the sale deed is valid, but that is not the case. In such cases, that sale can be fake sale. So it is always advisable that sale deed should be duly registered, and in otherwise it will not be valid sale deed. I have already clarified to you that what are the basic essential elements which should be part of the sale deed, and what is the registration process of the sale deed, that has also been explained, and I believe the query is clear.
Right. Yes, sir. So there's one more question, sir, from Mr. Sajjot Saini, that I am a resident of Canada. My mother owns residential property in India. Can she transfer property without my consent to my brother, who is well established in India?
Okay.
Yes.
May I handle this question?
Yes, yes, sir, please.
Okay. Your mother seems to be the sole owner of the property, and she being the sole owner of the property, she can transfer this property to your brother. And she can transfer by way of sale deed, she can transfer by way of gift deed. So under these circumstances, she being the sole owner, she is competent. It is her self-acquired property, and subsequently even such transfer cannot be challenged before any court of law. Because she is a living person, she has to be in fit state of mind. Under all these circumstances, if she is transferring, the transfer will be valid.
So there's one more question from Priyanka Sharma, that hello everyone, I am a non-resident Indian. I have a property in Delhi which is co-owned by me with my siblings. The dispute is lingering in a court of law from past 5 years. Can we get the matter resolved through some deed?
Okay.
Ms. Sharma.
When we are talking of the deeds, this is one of the deeds which can be used, that is family settlement deed.
Right.
Since the property is in dispute with your siblings, and it is very difficult to get the matter resolved through the court, because no timeline can be laid down, and you have already brought out that the 5 years have already passed and the matter is still before the court. The court has no choice but to follow the procedures of law, and while following those procedures and also keeping in mind the patency of cases in the courts, it is going to take a lot of time to resolve the issues through the court. Notwithstanding that, now in your case, since all the siblings are willing, and they want the matter to be resolved. So the best way is that all the siblings can enter into a family settlement deed,
Right.
and that family settlement deed can be presented before the court of law, and then the court can send the matter for mediation, and through mediation the matter can be easily resolved. And first you must keep in mind that when we are drafting a family settlement deed, all the family members have to be on the same wicket. If some of the family member or even one of the family member is not willing to continue with that family settlement, then that family settlement will not even be accepted by the court. So please ensure that if you are getting the matter resolved through family settlement, all the members should be willing to resolve this matter. That family settlement date can be basis for resolving the matter at a speed.
Right. So in the meanwhile, I would like to share certain requirements for the gift deed.
Okay.
So, in case you are going to enter into a gift deed, it is important to note that certain documents would be required apart from other essential requirements. That is the ownership documents such as sale deed, which will clearly depict the ownership status of the owner. Then there will be requirement of identity proofs of both donor and the donee, such as passports, PAN card, or even driving licenses. And then the original instrument, that is deed of gift, is really important, which needs to be produced before the concerned official while you are entering into a gift deed. Apart from that, if you are going to execute a deed through attorney holder, it is very important that you should have the original power of attorney in your hand, so that the same can be presented before the concerned official while you are going to enter into a deed of gift with your blood relative. So this is regarding the gift deed process.
Okay, thank you Akriti for explaining these requirements for registration of a gift deed. These documents are very important, and all these documents should be available with you when you are entering into a gift deed registration. Any other query?
Yes, I am looking for a few more questions, and
Okay.
I think so. There is no more question as of now.
Okay. As we have told you that there is one of the dates is called relinquishment date, and the relinquishment date is also that when there is a property which has been inherited, and the one of the parties does not want to inherit those rights, then those rights can be relinquished in favor of his or her siblings by that party. So during a relinquishment date, again you have to say that it is properly executed, and the person who is relinquishing her or his rights, that person should clearly bring out in the relinquishment date the details of the property, the part of his share which is being relinquished by him or her, and also the relinquishment deed also be duly registered. And if it is not duly registered, then again it will not be valid at the time of the transfer of the property. So relinquishment deed can also be a basis for transfer of share in the property in the to the siblings, and generally it is in the case of inherited property. Any question?
No, sir, no question so far. But
Okay. Let me further clarify regarding gift deed we were talking about.
right.
Yeah, we have seen that when you go for registration of the gift deed, some documents already explained by Advocate Akriti, but you must ensure that you should have witnesses with you at the time of registration of the gift deed, and also registration of gift deed is compulsory, and it is required as per the Registration Act. And so far as the other details which are required to be mentioned in the gift deed are that the details of the donor and the donee should be clearly mentioned. Donor is the person who is parting with the property or giving gift of the property, and donee is the person who is the recipient. So details of the donor as well as the donee should be clearly brought out in the gift deed. Secondly, the details of the property which is being gifted, whether movable or immovable, should be clearly mentioned. Thirdly, all the immovable properties which are to be transferred, to be gifted, those details of immovable property should be clearly brought out in the gift deed. Fourthly, If any encumbrance is there, that should be clearly brought out. Encumbrance on the property should be clearly brought out in the gift deed. Fourthly, in the gift deed you should ensure that the certificate regarding the fitness of the person, that the person who is making the gift to the donor is competent, and as well as he is fit, he is in a physical state of mind, he is in a sane state of mind, he can gift the property to the donee. And also during the gift deed, the witnesses should be present, the gift deed should also be duly signed, and also it should be when presented before the registrar always verifies all these documents and details, and thereafter only the gift deed is registered. Even when you are going for the sale deed registration, let me clarify that once the sale deed has been presented to the registrar has to enter the details of the registered sale in the register. So you should have the copy number, the book number, the page number, and the serial number, which should be clearly mentioned on the on the sale deed. Subsequently, if the details are to be verified, so details can be easily checked from the office of the registrar.
Yes.
Right?
Yes, sir. I would like to add on something, sir, may I?
Yeah.
So generally when we see in the case of NRIs, there are properties which are lying in India, and some occupant or tenant is also residing in that property. So in that case, it is always advisable to enter into a rent deed to ensure that the document is properly executed, so that your ownership status remains secure, and in case any difficulty or any legal complication arise in future, then you can use that deed as a evidence in the court of law. And also it becomes easier for you to evict the tenant or the occupant in case he is trying to retain the possession in an illegal manner. So it is very important to enter into a rent deed, which is also very crucial deed, especially in the cases of NRIs who are residing away from their properties in abroad.
Okay. In continuation of this also, Akriti, I would also add on here that when you are drafting a rent deed, you have to have basic clauses of the rent deed to be very clearly mentioned. What are those clauses? I will just highlight the important clauses. That the person who is renting the property, that is the owner, and the tenant, the details of those person, both the person should be clearly brought out in the rent deed. And secondly, the rent deed should also have the details of the property clearly mentioned. Then the amount of rent, the consideration which is there, that is to be mentioned, which is to be paid as a rent to the owner by the tenant. Also, the details of the fittings, fixtures should be clearly mentioned. There should also a penalty clause that if any damage is caused to the property, then the tenant would be liable. And there can be special clauses also, like the pets are not allowed in that area. What are the timings for the music and all that in that area, that should not, the tenant should not violate the prevalent local rules which are there in that area. So all these clauses should be clearly mentioned in the rent deed, so that subsequently, if the tenant is violating those terms of the rent agreement, it is easier for the landlord to evict the tenant.
Right, sir.
So any other question? Anything on deeds we would like to clarify further?
So yes, I think we should add on regarding compromise through court in case as a compromise deed.
Okay, I just discussed about the family settlement deed.
Right, sir.
Even that was part of the family, when the family's dispute pertaining to property is going on in the court. But even if, as Advocate Akriti has brought out, if there is a dispute between third parties, between you or third parties, and you want that this dispute is to be resolved by early, then another step is that you can enter into a compromise deed or a settlement deed, as you said.
Yes.
This compromise deed again can be drafted, bringing out all the details and responsibilities, liabilities of the people involved, and how the property will be demarcated, how the property can be distributed after the dispute is over, and all those, covering all those aspects in the compromise deed and duly signed and attested through the witnesses, this deed can be produced before the court of law,
Right.
and then such type of disputes can be resolved as early as possible through the way of compromise deed.
Yes.
And when such compromise deeds are presented before the court, the court generally sends such cases for the mediation,
Mediation.
and it goes for the mediation cell, and then mediation cell puts its stamp and the matter is resolved. And this is the speedy way of resolving the dispute in a court of law.
So we have a question, sir.
Okay.
So the question is from Mr. Rai that hello, my aunt is settled in India and owns a bungalow in Chandigarh. She has expressed her willingness to gift me her bungalow. She also has a son and daughter. Can she do so, sir?
Okay. What is the name?
Mr. Rai.
Okay, Mr. Rai, let me clarify to you. As I brought out earlier also, that the property can be transferred by the person who is exclusive owner of the property.
Right.
In this case, your aunt is a mother.
Yes. She wants to gift her bungalow.
Her bungalow. She
Aunt.
being the exclusive owner, your aunt being the exclusive owner, she can gift it to you because it is her self-acquired property or it is his personal property. So even if his children have objection, but she is giving it to you voluntarily. Number one, it is very important that she should be giving it voluntarily. She should be the exclusive owner of the property, and she should be in a fit state of mind. If these conditions are met, then any gift deed made by her in your favor will be a valid gift deed, and even if her children want to challenge it subsequently, they may not succeed. And you must ensure that when the property is being gifted, all those details which we have mentioned about the elements and registration process, that should be duly followed. And the gifted registration is mandatory again, and this gifted should be duly registered in the court of law before the registering authority. Under these circumstances, you can become the owner of the property once it is gifted to you.
Yes.
So, any other question?
No, sir. I think the
Okay.
questions are over.
Okay, ladies and gentlemen, we have just gone through various kinds of deeds, that various legalities which are involved in transfer of that property by way of sale deed, by way of gift deed, whether it's a relinquishment deed. We also discussed about the compromise deed, family settlement deed, and all these queries which we have answered. We have tried our best to answer your queries, and in case you still have any doubts left, you are most welcome to shoot your queries to us. You can send these queries at our website, query@nrilegalservices.com. It would be our endeavor to answer and attend to all those queries and come back to you with the answers. And my only advice to all the NRIs is that they should ensure that whenever they are transferring their property or doing any act through concerning their properties, that should be through the trusted people and through the law firm, and they should ensure that everything is done legally, and it should be valid in the eyes of the law. And we thank you so much for hearing us and for giving your time, and we'll come back to you with another session of Ask Me Anything. Till that time, please stay well, stay happy, and stay safe. Thank you so much.